My guest today is civil rights attorney T. Matthew Phillips, who recently filed a class action lawsuit in a United States District Court, arguing that California failed to properly train judges that parenting is a constitutional right. And the suit seeks monetary damages for every day that the family courts kept fit parents from their children. This is the first of a two-part series on this topic. And one reason that we're speaking to Matthew is because Tarrant County parents have experienced the same injustices described in this court filing. So Matthew, thank you for your time today. And we wanted to start by having you describe the constitutional violations described in this lawsuit.
The constitutional violations that we're alleging are specifically the 14th Amendment and the First Amendment. Frankly, the way the lawsuit is written, all you'd have to do is change the word California to Texas or Florida, Connecticut, what have you, and the lawsuit could be done because the principles are the same. What we're alleging is that that these parents are having their 14th Amendment right to parent violated, and also their First Amendment right of familial association, that's being violated. The First Amendment right of familial association says that parents get to have private speech with their children. But unfortunately, that's not happening too often, where parents are stuck in supervised visitations, or they're just simply not allowed to speak to their children at all. But the constitutional rights at stake that you had inquired about is the 14th Amendment right to parent, which says that parents have a right to care, custody, and control of their children. And the First Amendment says that they get to have private speech. So I don't know if that was too long-winded,
Yeah,
but
that's great.
that's
Good introduction for this. Can you talk a little bit about some of the past Supreme Court rulings that have kind of reinforced this?
Well, yeah, there are several decisions from the Supreme Court. There's actually 13 Supreme Court decisions that speak specifically to the idea of parenting. And the most recent one is Troxel versus Granville from 2000. And that really defines what it means to be a fit parent. First of all, parents are presumed fit unless or until they've actually been declared unfit. So what is a fit parent? Well, someone who hasn't declared unfit. And unfitness is something that happens pursuant to a fitness proceeding where the state, not your ex, but where the state brings a proceeding to say that you've engaged in child abuse, child neglect, child abandonment, or child endangerment. And if a person is found, by the state to have engaged in those things, child abuse, child neglect, well, that's actual harm to a minor. And if you've actually harmed a minor, well, they can take your child away if you cause harm to them. The thing is, though, is so many instances you hear people losing their kids because they apparently had a scuffle with their spouse. Well, or maybe they, I don't know, stole nachos from 7-Eleven. But even if you were a thief, even if you did domestic violence to your spouse, what does that have to do with your minor child? The rulings of the Supreme Court are very clear. You cannot lose custody of your child unless you actually harm the minor. And so my clients have never actually harmed their minor children, and they've never even had that alleged against them. There are no allegations of child abuse, child neglect, child abandonment. The point is they lost their custody because, as we all know, the family court is the first court in America designed not to dispense justice, but rather to generate revenue.
So, do you see this as the right time for parents across this country to kind of take your initiative and apply it in their own home states? I was going to say there's a lot of issues that are competing for the attention of the higher courts right now. How do parental rights? Is this the time for parental rights to become priority across the country?
I actually, that's a very astute question. And my thoughts on that is I would just look for a second at abortion. Now, remember, abortion is a right protected. Well, strike that. Abortion was at one time a right protected by the Constitution. Pursuant to Roe versus Wade back in 1973, the Supreme Court said that the right to abortion is a fundamental right that the Constitution will protect. Well, the Supreme Court took that away in 2022. And essentially, the Supreme Court said abortion is no longer a fundamental right, just because the Supreme Court has the ability to declare what is and what isn't a fundamental right under the 14th Amendment. It's just kind of interesting historically that abortion had a 49-year run and it just recently ended last year. Well, now let's look at the right to parent. The right to parent is a fundamental right. It was first established to be a fundamental right back in 1923 in the case of Meyer versus Nebraska. Now, that ruling has stood for 100
100 years.
years.
Wow.
And so the right to parent, again, has been a fundamental right, a liberty interest that the 14th Amendment protects. And I fear, though, that the powers that be may want to take away the right to parent. I think it's kind of an alarming thing. There are social issues, I think, brewing underneath the surface because parents are adamant that they have the right to be parents. But we see the state more and more wanting to intervene and control.
Yeah. How's this lawsuit going to be moving forward? Can you give us a summary of what to expect?
Well, what happens procedurally is we get the complaint served upon the defendants, and they would respond. I would anticipate in 4 to 6 weeks they may request an extension, and then there would be a hearing. I'm presuming they would file a motion to dismiss. That's probably what they'll do. And I've tried to anticipate their arguments. I think the argument that if I were the attorney for the state of California, I would argue that the Judicial Council exclusively gets to decide the policy for California courts. And I think that's fair to say that any state should have sovereignty, if you will, in deciding the judicial policy. However, that being said, I think if a judicial policy falls below the minimum constitutional guarantee, I believe the federal government can step in and order the state to come back up to snuff again. So that's the point. And again, I'm just so concerned about this because the parents in court, in family court particularly, are not getting the minimum constitutional guarantee. The right to parent is a fundamental right, which means they can't take it away willy-nilly like they do. But we all know whether it's Fort Worth or wherever it happens to be, they take away children like it's lunchtime because it benefits those involved. All the family court attorneys who can't wait to prey on the vulnerable parents because they know the parent will spend their last dime to get their children back. And it's
Yeah,
anyways.
we're going to explore that in our next episode here. So let's go ahead and that's another big topic. We're going to explore that. So let's go ahead and wrap this one up. Again, I appreciate your time. And if anyone wants to follow this lawsuit, what's the best way they can do that?
Well, they can always contact. There are several the moms groups, and I think that I can't remember all the names. There's a because I'm not involved with the. I guess there's a lot of activists involved who support the case, but there's a mom army. I think it is, and a dad army, and a Me Too moms and a Me Too dads. Or if anybody has questions, they can always contact me. My email address is simply tmatthewphillips@aol.com. And I'm old school like that. So.
Yes, keeping AOL rocking. All right. Well, Matthew, thanks for your time. We'll talk again in a few minutes for our second part of this series. So,
thank you very much.